Ethnic youth leaders have urged the Attorney General of the Federation and Minister for Justice, Lateef Fagbemi, to tender an unreserved apology to Governor Siminalayi Fubara for allegedly falsely linking him to the bombings in Rivers State. Well, according to the youth leaders of the different ethnicities in the country, it was curious that the AG, Attorney General, who is the Chief Law Officer, refused to name key dramatis personae in the Rivers crisis, but put the blame on Governor Fubara. In a statement signed by Godwin Maliga, who is the president of the Middle Belt Youth Association, blaming one side for the crisis is not the way to achieve reconciliation. The AGF last week said Governor Fubara failed to dissuade the militants from vandalizing oil installations. Since the return to democracy in 1999, there have been 5 state of emergencies declared by presidents. Past president and, of course, the incumbent, making it 5. Some analysts have criticized the exercise of executive powers to suspend an elected state governor and the House of Assembly members, while others say suspending an elected governor and members of the House Assembly was not envisaged by the Constitution. How will the presidential power of declaring a state of emergency in a state impact the politics and governance, not just of that state, but of the country as a whole? What are the implications and fallout of a state of emergency? And like I just said a while ago, in the state of Rivers. We have joining us in the studio, Frank Amadi, Dr. Frank Amadi. Sam Amadi, sorry, because I discussed with Frank Tietie earlier, Director, Abuja School of Social and Politics of Thought. He joins us to look at this issue. Glad to have you join us, Sam.
Thank you.
Now, like you had me ask there, how will the presidential power of declaring a state of emergency in a state like Rivers impact the politics and governance of the country as a whole?
Well, first, I think we we borrowed, obviously, provisions from the U.S. Constitution, and perhaps we didn't look at the jurisprudence of that in the U.S. constitutional history. The language of the Constitution in terms of when it appears to the president, there's a clear and present danger of actual breakdown of law and order has kind of disturbed U.S. jurists trying to say what exactly is clear and present danger. And so there's a lot of subjectivity to that. So the president can put two and together and say, it seems to me there's clear and present danger of actual breakdown. And if you look at the history of this crisis, it could pick and choose, events. And so what this means, first, it kind of shapes the power between state and federal to the federal. You see, federalism is always a kind of a competition, contest for power. So you share power between the federated states and the federal government in a way that is tenuous. So they're always fighting over. And that's why if you look at cases of federalism, it's about how those powers should be calibrated. In the US, powers not enumerated are reserved for the state. So you see when President Trump would say, give back the state the power to choose whether there should abortion, whether transgender.
The states have such power.
They should. The federal government should only deal with this. But in Nigeria, because of our history, the odd thing about federalism is that whereas in the US, the state ceded power to the federal. In Nigeria, the federal seem to have created the state, or whether it's military rule, we say 35 states created a military, 36 states from 12, from region. So the states seem not to have their own, the kind of status and historicity that US states have. So this kind of politics, the power of the president to disrupt democracy.
Because even in the US, the states have their Supreme Courts.
And the Supreme Constitution. So even the First Republic, when we had Western Republic, even at that time, you see that there was also an emergency law that allowed the federal government of Tafawa Balewa to disband the Lagos State, Western Nigerian, and remove Adeboyero and all that. So the problem is that it skews the politics in a way that the president, who is, for all purposes, a partisan, no matter who the president is a partisan, and there's likelihood of political conflicts with states run by a different party. We are a party-based, we're not a one-party state, multi-party. And so the president is given a tool to pommel a threat, a sort of demarco, that if a governor plays too hard, he could suffer, this sledgehammer effect of disruption. And the president would say, it seemed to me. In fact, fifth columnist, the federal government can even instigate some of those activities that could create that perception of actual breakdown. That's number one. So you see that under Obasanjo, when Ekiti State suffered, Plateau State suffered, it was all written around that some political events that preceded them. And so that's the problem here, that whereas President Tinubu can escape under a fig leaf of legality to say, the Constitution says, if it seems to me that there's likelihood of real present danger of actual damage, he can escape legal. Say, okay, fine, that's a power. But the second issue is whether it needs to disrupt the democratic structure, the second one. But the key point is that our Constitution fails to streamline when and how, what would be the parameter for this actual breakdown of, and what should be what the president can do in invoking the power of majority. So it makes the states vulnerable. So this political vulnerability can be weaponized, activated by a president who is seeking election in a context where we are now, where one can predict that the ruling party may struggle to win. So if it is reasonable to assume that the ruling party is struggling, if we do poll in this country, you see that the present number will be near basement level. It's going to be very low in terms of acceptability. It happens for policies.
Well, that's objective.
I'm saying if we do, I'm just predicting.
Yeah, I mean,
based on people are struggling, inflation,
the economy.
It doesn't have to do with you. Once the economy is that bad, there are going to be numbers to reflect. So if you have that kind of number, a president might be tempted to bolster his electoral chances by knocking down on critical states. So that's the danger. Whether Tinubu intends that or not is a different. So I think that constitutional provision and that possibility of doing this cripples and kind of threatens a robust federalism. That's what Shoyinka is talking about. So in my view, I think that if either we remove that provision or we create a provision that clarifies what the president can do in the name of state of emergency, calibrate levels of intervention, maybe substitution of human rights, maybe some kind of extraordinary use of military forces, but not anywhere to disrupt and suspend or however, impede democratic exercise of state power through elected officials.
We were discussing, myself and Frank, the fact that Sarah might not, well, I think the way he said is that they don't have the local standard, but that the governors of
those states,
PDP, who have some states, particularly the ones that are closer to Fubara, have that local standard and they can go to court. I want you also to discuss about that in terms of how it affects
the thing about the court is that the recent Supreme Court decisions towards kind of narrowing down when a dispute seems to arise between the state and federal government is one hurdle. But beyond that, the state government, if anybody is going to have locals, obviously is a citizen of River State. Okay. The governor whose tenure has been truncated sort of.
He's not my governor. He's been suspended. Well,
when you're suspended, you don't mean you're not a governor. For example, when the staff is suspended from employment,
he's still a part
staff, but your functions have been limited. So he's still a governor under suspension.
So you can go to court as a governor?
Yeah, you can go to court as a governor, but status is suspension. And he's challenging that suspension. So whether he calls himself Fubara, the man who ought to still act as governor or governor, but the point is that suspension does not vitiate the status. It puts it in abeyance. You cannot function, but the title, the position stays until whatever happens. So he can go to court. A city of Rivers can go to court because under the claim that he is entitled to be governed by elected governor. It doesn't mean they will win. Other states can go to court in an ancillary argument that what has happened constitutes a threat to them as well. Not because they're PDP, but these are states that may likely fall under this situation. So I think that depending on the Supreme Court focus, a broadly defined locus should embrace. In many cases, Supreme Court has swung from one point to another. They say, okay, a well-meaning NGO with demonstrated stake and commitment to rule of law or particular
democracy
can be allowed. In the case with NMPC on environmental, there are environmental center to go to court and say because they are committed to environment, they have locus. So if the Supreme Court is expansive, use what we call actual popular action and the right of citizens, they can expand it. But if they want to be conservative, they can restrict it and say, okay, show overriding injury or benefit that shall continue.
Why?
Using a very narrow, platform.
Now, explain this before that we let you go, just briefly. I mean, I've discussed with one or two lawyers, and what I was told is that where the law, the Constitution is silent on a matter specifically, that the president can then take action which would deem right because it is silent on this. And that would probably then help if one goes to court to then clarify or maybe put it in bold letters specifically that this can't be done or this will be done.
Well, look at it, it's two ways. One is judicial attitude. First is what grayness, is gray. It's
gray
not
area.
Too clear. So the court may be tempted to resolve it in favor of the president. And the court also could be guided by, what they now call doctrine of necessity. But that's what it simply means that the court can say, well, the fact of the matter is, if there is likelihood that X might happen, what the president is going to do, we consider the president. The difference, we defer to the president to decide what level of intervention is appropriate. In our sense, we might think it should be less than this. It should not involve disrupting democratic arrangement, but the president might consider it proportionate to his subjective perception of the danger. Now, in constitutional interpretation, in more developed jurisprudence, what happened to it if, and Lord Marshall said that very clear, in the case where the U.S. president claimed the power during the wartime to deal with steel manufacturers. And the Supreme Court says, where the Constitution is express, the president power is magnified. Where it's prohibited, the president's power is zero.
Yeah.
But where it does not speak to, the president's power is sizable. So if it expressly say he can do this, big power, he can restrict it. If he doesn't say so, if he says he shouldn't, zero power. But where it does not expressly say and does not expressly constrain executive power, the president's power is moderate and depends on the context. So in this case, two things are going to happen.
Which will now then depend on interpretation when you take it to court.
Exactly. So it does depend. If a typical court will first say, factual, are there circumstances that should suggest to Mr. President, not this judge, but any president, that these events could lead to breakdown? And reasonably, I could say yes. The bombing, destruction, the president can say, well, this seems to me. Second level of analysis will now be, does this power to declare emergency require actions in the nature of removing the state government? Some of us have argued that if you look at section 1.3, we talk about this country cannot be governed except by democratic means. And if you look at what the Supreme Court has said concerning local governments and the powers of the state to dissolve them, it becomes clear that the Constitution does not seem to suggest that the president can dissolve elected officials. It does not limit the president's extraordinary measures he can adopt. But those extraordinary measures should not be in the nature of disrupting democratic institutions.
Okay.
So it's a question of how the court, if the court accepts the argument that elected officials are far removed from being part of a extraordinary measure, then the court will say wrong. But if the court thinks that the extraordinary measure could include disrupting, the court cannot say rule in favor of Mr. President.
All right. I mean, we've talked about the presidency, but we seem to be forgetting, because this is also, it's inclusive. And just briefly, I just felt I should bring it up. The question of, again, the Constitution, 2/3.
Absolutely.
2/3 to approve or override.
Yeah.
But then the House and the Senate used voice votes.
Okay.
And people like Ireti have come out to say that you cannot use a voice vote to determine the numerical,
where the Constitution is stipulated.
Yeah. So, with what the NAS has done, what does that leave us in a democratic setting?
Very good point. I think that the president's quote-unquote error, if you think it's error, is even manageable, tolerable than the House. The president's decision is in better footing because the president acts, there's a grayness, vague. So he could say extraordinary measure could include removing president, governor or not. It's arguable. I think it shouldn't, but anybody can argue. The one of the House is slam dunk. The power to make law is as specified in the Constitution. Now, they erroneously imported the so-called Section 60 or so, or where they have a power to supervise their proceeding. No. The Supreme Court has even said it very clear. In many cases, as early as 1980-something, where the same House approved an appropriation through a reconciliation of both Houses committee, not by vote, because first they did it and there was discrepancy. They brought the joint committee, they approved and they sent to the president. In the case of AG Bendel and AG Federation. And the Supreme Court said, no, that appropriation act is invalid. You have to follow those expressly laid rules. So this approval by the National Assembly will be vacated by any serious Supreme Court. Any. Because one, you can't decide when the Constitution have told you how to. You can't make resort to your rules, and you can't make resort to your so-called right of self-regulation. Those rights are rights to regulate yourself where the Constitution has not, because the power you're exercising is expressly stated in the Constitution and the mode. So when there's a vagueness, if the Constitution says, in doing this, you must do this, then you can't change it. If the Constitution says you have the power to do this and didn't tell you how to do it, you have the right to devise rules to do it. So that confusion, I think they have caused Mr. President a problem, because the President declaration of what do you call it?
State of emergency in Rivers
would be nullified by the Supreme Court because it's invalid, because the subsequent act to ratify it, the National Assembly failed. They can never use their rules to override the express constitution. So, all right. So that's what it is. So the court could say, Mr. President, even though we don't agree with your subjective analysis of the facts, it's reasonable. And that's what we call doctrine of deference. So they defer to him, but they can't defer to the National Assembly to go against the Constitution.
Dr. Sam Amadi, then it is strange. I mean, we will leave it there, but then it's strange that that's why I brought it up. People are not talking about, nobody's talking about going to court, taking them to court or that, so we can determine that. Yep. You know, from what you have said, that is, call it a lame slam dunk.
Slam dunk. The president can escape, but the House can't escape.
Thank you so much, Dr. Sam Amadi.